Describe the general purpose and handling of all evidence from the time of discovery through disposition. Once a crime has been committed, police officers, investigators, detectives will tape off the crime scene to prevent tampering. Evidence is collected and prioritized in order of size. Large items of evidence is collected first on down to trace evidence. Once the smaller trace evidence is collected by way of vacuuming, taping, or tweezing, it can be taken to the lab for analysis. These items of evidence also include hair or any blood samples, bullet casings, and dusted fingerprints. At the lab, there will be a detailed examination of the elements or structures of items for discussion and interpretation. They will be looking at trace evidence, body fluids, blood samples, DNA analysis, blood spatter pattern, hair and fibers, fingerprint, powder, or any chemical castings of footwear, clothing, and firearms left behind. Some of this evidence must be preserved while others not. The evidence is logged in and tagged with the date of the booking and incident report number of the offense. It is the responsibility of the Attorney General and other local, county, and state investigators to preserve evidence. This also would include prosecutors. Most of the evidence that must be preserved are the items that play a significant role in the suspect's defense, such as materials and other evidence. Once all evidence in the evidence locker can be checked out by defense and prosecuting attorneys for examination, this is a time of discovery. If the defendant pleads not guilty at the point in case is set for trial, right away, this attorneys will start to file papers for trial. There are usually pretrial motions to test the waters for legality used in all searches and seizures and changes in venue. Before trial can exchange the information begins, which is discovery, this is set time limit for pretrial motions to be filed. Usually there are 2 weeks to 10 days of arraignment.